Okay, I think we can start. So, welcome everybody. First of all, this is Soykan, and we have Caner here. First of all, I would like to talk about ourselves, introduce ourselves, and then we'll give you information about the CFE cert, and then we will move into the agenda, and then we will tell you about GDPR awareness for financial institutions. So Caner, yeah, you can start with introducing yourself, and then I can take the rest.
Hi everyone, thanks for joining in for today's webinar that we will be talking about GDPR awareness in financial institutions alongside my distinguished colleague Soykan Suçmaz. I myself is a regulatory lawyer working currently at Wirex, which is dealing with both crypto and e-money services. And I'm currently leading their regulatory affairs team and their global expansion projects alongside the regulatory aspects. And we spent last couple of years together with Soykan working alongside different projects for different fintech firms, both in financial regulations area and also specific regulations areas like GDPR or competition or any other specialist regulations we would call. And we thought that it would be useful for some people to get to know more about or have the chance to discuss more about GDPR awareness, especially from the fintech perspective, from relatively small firms perspective, what are the main challenges and how to tackle them. And hopefully we will increase our knowledge by the end of this webinar all together with the audience and panelists ourselves. Yeah.
Thank you, Caner. So I'll give you intro about myself. So I'm Soykan Suçmaz. We have been working with Caner for long times, for many years. So we moved to London like 2.5 years ago, and we were working together for Financial House Limited, which is a FCA regulated financial institution, e-money institution. And yeah, since that we've been dealing with GDPR related transactions, and also I'm leading the legal team in Financial House. Yeah, basically that's it from our side. We are based in London. If you have any questions after let's say the webinar, you can see our emails here, so you can just email us and we can discuss further, or if we can help anything, we would be more than happy. So let's move to information regarding CFE cert. So CFE cert provides auditing, certification, training services in a wide range of standards such as GDPR, information security, business continuity, quality management, and personal information management systems. CFE certification also is a certification body accredited by UKAS and IAS. So CFE certification can provide you certification on behalf of these bodies. Also, it's a member of CPD certification service, the British Education Accreditation Institution. So if you need anything related to these, let's say, subjects, you can contact CFE Cert and they will help you. So our agenda today will be driving the GDPR awareness for financial institutions. As you know, it will include driving GDPR compliance, what are the main rules of GDPR, and why is data protection important for financial institutions. We will start with the history of data protection regulations, just as a background. So in 1984, Data Protection Act passed in the UK, and in 1995, Data Protection Directive passed in the European Union, and also 1998, Data Protection Act again passed in the United Kingdom. In 2000, there was this international safe harbor privacy principles established, and then in 2012, European Commission announced its GDPR plans to develop such regulations. And in 2015, the safe harbor privacy principles overturned, and then it replaced with EU-US Privacy Shield in 2016. And recently in 2016, GDPR approved by the EU Parliament, and then took effect in 2018. Moving to the next slide. I will be trying to explain you what is a personal data and what information should be accepted as personal data, and different types of, let's say, personal data. I will try to tell you about them. So for GDPR, GDPR includes lots of identifiers, and also, let's say, information related to a natural person, which are identifiable. So in this context, what will be deemed as personal data will be, let's say, any kind of information relates to a person and it identifies it. This can be name, this can be a, let's say, passport number, this can be the location of the person, this can be an IP address, cookies, genetic data. Also, this can be factors related to physical or psychological or mental, economic, any kind of information which identifies that person from the community and distinguish it, could be deemed as personal data. Another, let's say, another category, another type of personal data is special category data, which is specifically defined in the GDPR. So I will give you more details for personal data examples, and also I will give you some examples from special category data. So let's say for this identification personal data, name, surname, as I said, mother name, father name, can be deemed as identification related to that person. For example, contact details, address, email address, telephone numbers, these are also personal data. Payroll information, disciplinary investigation information, performance evaluation reports, these are also personal data which are related to the person. Legal action, so information related to, let's say, a legal case related to that person could be also deemed as personal data. Customer transactions, these are also personal data. Let's say an example like call center records, invoices, check information. Also, we can say, let's say, bank account balance. These are all, again, personal data. Physical space security. Let's say an employee is entrance and exit registration of an employee in a company is also deemed as personal data. Risk management, such as information provided information process to manage commercial, technical, and administrative risks. Professional experience, such as diploma information, courses attend. These are all, again, personal data under GDPR. Visual and audio recordings of that person can be also a personal data. Moving forward to the special
maybe I can also like add in to wrap things up.
Yep. Please go ahead.
Yeah, as you can see, there are almost unlimited types of personal data, which all comes to the one simple point, being identifiable. So this is, I think, the key when we are deciding whether something is personal data or not. If you can just relate someone and identify someone, and if there is a little bit of other information that is related to identify a person, then we should categorize this as a personal data. And Soykan has given, I think, very extensive number of examples when it comes to, but it's also important to note that these are not limited with
yes.
or just examples given. We can easily say that it is also unlimited categories of different personal data. But as Soykan was just coming to that, I think special category data, which is already described in the regulation. I think this is also very important. I think we can ask our audience if, for example, what do you think would constitute a special category data? Is there anyone who wants to, I don't know, ask or give an example? Maybe we can just wait for like 20 seconds if something wants to discuss whether a special type of data is a special category data, or maybe a gray area that do you think that this is special category data or not? Let's wait for a bit for audience to think, and if not, we can just give. Soykan, I think you can just continue. Thanks. I think Georgina. Thanks. Scan of passports. It contains biometric data. Especially where it's used for identification purposes. Biometric data is definitely a special categories data. I don't know if you agree, Soykan, but
yes, of course. Biometric data is deemed and accepted as a special category data.
Especially with the new passports, right? We all carrying our biometric data in our back pocket, or sometimes even in even other places.
Yes, exactly.
When you think about it, it is kind of important. Sometimes we don't realize how important the passport or something we carry is all about us. Thanks, Georgina, for contributing, and I think you're totally right. You can.
So basically, we can say special category data is more sensitive than just regular data, regular personal data. So these could be used in a negative way and discriminatory way. So I will give you some examples. As Caner said, these examples are not limited. So I'm just giving you let's say, the mainstream examples for the personal data and also the special category data. So for special category data, we can say political opinions of that person could be special category data, religious or philosophical beliefs, biometric data, genetic data, data concerning health, data concerning a personal sex life, data concerning personal sexual orientation. These are, as you can understand from just the names, these are all very sensitive, very important, very personal, special data related to the data subjects. Moving to GDPR principles. So in GDPR, we have 6 main principles. In the Data Protection Act, it's 8, but in GDPR it's 6. It seems like there's 2 differences, but there is only 1 in practice. So I'll tell you about the principles. So we have 6: lawfulness, fairness, and transparency. So the data you should process should be lawfully, fairly, and in a transparent manner. Purpose of the limitation. So purpose limitation. So purpose limitation is that you need to collect the data just for the purpose you need it. Nothing should be more than it. Data minimization. It should be, again, like adequate, relevant, limited to what is necessary. And it should be accurate. So the accuracy is another principle, and it should be kept up to date. Storage limitation. So storage limitation is that if you need it for, let's say, 1 year, you should keep it for 1 year, not for longer. The other principle is integrity and confidentiality. So the data should be confidential and kept in a secure place. Accountability. This is the difference between the principle of the DPA and the GDPR. So accountability, the responsibility for that data store should be with the controller or the processor, and they should be accountable for the data. Moving to the next slide. So as you may understand, this lawfulness of processing is a very important principle, and we have 6 options under this principle. So lawfulness of the processing is also known as the legal basis of the processing. So you should have a legal basis, a lawful reason to process or control or collect this data, this personal data. So who should, before going into these lawfulness of the processing, I would like to tell you there is a limit of 250 employees for companies to keep records of their processing. So if you have in your company more than 250 employees, you need to keep the records. What happens if not? If you have less than 250 employees, then you only need to document the activities which are not occasional. So what I mean by not occasional, I mean if it's not just like a one-off transaction, one-off occurrence. So if it's like let's say ongoing, then you need to keep a record of these data that you're processing. And also, let's say if these data that you're processing is likely to result in a risk to the rights and freedom of individuals, you need to keep the record of these. Also, if the data you are processing is involving special category data, then you should definitely keep the records of it. Coming back to lawfulness of the processing and the options under them, which are consent, performance of contract, legal obligation, vital interests, public interest, legitimate interests. These are the 6 options that could be the reason, the legal basis of why you are processing this data. So before moving to the next part, if there is any like questions, please kindly, anytime you can write your questions on the chat, so we will try to answer them with Caner.
Yeah, so, exactly. Like, so I think now everybody is so focusing on consent, but it should also be noted that there are actually more than one or two types of lawfulness when it comes to the processing. And when you're dealing with some different firms and suppliers, they usually ask, they usually send you a small form that that is asking what is the reason, or like what is the rationale behind you processing data on behalf of me and stuff. We always focus on consent, but we actually we all need to know that we have performance of a contract, which could be widely used, and also legal obligations, which we usually refer when it comes to the financial institutions. They usually have both legal obligation and performance of contract reasons for as a matter of lawfulness when it comes to the processing, because regulatory bodies usually require you to have certain information. And for small fintech firms, especially dealing with bigger suppliers, bigger payment processors, to able to expand their ability to provide services, it becomes vital to be able to identify these, so you can fill out forms and comply with the relevant suppliers' requirements. I think it was very important to note these all. Thank you, Soykan. But interest and public interest, they are like less likely to occur on a daily life of a financial institution. But first three, I think they are as important as the other ones.
Yeah, after GDPR, Caner, you know, like we are giving consent to everywhere online. So yeah, all the companies, all the financial institutions, even website, they're always like asking for consent. So the main reason is that like they need to have a legal basis and lawfulness for the process of your information. So that's why we are like accepting these terms and conditions, giving consents related to our personal data.
Yeah, and when we are talking about consent, we also need to maybe note that consent should be clear. So any consent hidden somewhere that is not possible for a bystander or a normal person to understand, this is very unlikely to be accepted as a proper consent. When it comes to the GDPR principles, we all have to know that it should be as clear and as simple as it could be under the circumstances.
Also needs to demonstrate how you're gonna process and where you're gonna share this personal data.
Exactly.
Let's move to the next one. So information audit and records. So we would like to tell you how you can conduct information audit. Why we need information audit? When you record this personal data, if you have your own, it doesn't have to be like this. You can build your own information audit method or system. So if you can divide them into columns, and then like as you can see here, there is like information related to that personal data, and it demonstrates the personal data. It says like in here we made like five different categories and information columns for each personal data and data subject. So let's say we have an personal information we store. We need to record it with these information: what personal data you hold, where it came from, who you share it with, and legal basis for processing it, who is responsible for the personal data you store. So these are very important, and I can understand that it seems like just for one data you also record like 6 or 5, 10 more data, it's a mess. But you need to have this in order to prevent any like problems in the future, or in case there's a problem, then you can go to this personal data information audit and see all this information, which will be useful to sort the problem out later on. For example, we said that consent is one of the, let's say, legal basis for processing the data. But what if a person who gave consent earlier withdraws that consent? So, for example, we have an information audit and we have legal basis for for processing it as the consent, and then the consent is gone. So, in that case, should we stop doing the data, or should we check if there is any other legal basis? So, if we have this information audit in the first place, and we have this legal basis, one, consent, and two, let's say, one of the other options, then even though the consent is gone now, we can keep the data based on the other legal basis that we are keeping the data of. Moving to the other slide. Yes, Caner, maybe you can take the mic here.
Yeah. Thank you, Soykan. I think it was very useful, especially noting that sometimes it is also identified as data mapping. So you can keep the track of how you get the data, how you process it, what is the legal basis, who you share it with. So when you have it all sorted out and identified, it's very easy to deal with the data subjects rights, which we are now getting into there. So we are always looking from the financial institutions side as working professionals, but we are generally we are data subjects ourselves, and it's very important for us to know what rights we have, and GDPR contains some rights for individuals and strengthens others that already exist under the Data Protection Act. And knowing that data subjects' rights are crucial to our roles in life, what are these? It's good to have. First, it starts with right to be informed, and I think this is self-explanatory, and right of access. So you can always ask for an access which data are being processed on behalf of any provider or any legal body that it is processing. And rectification, it is also very important that you can always correct any data which is wrongfully being processed. And erasure, I think Soykan initially mentioned about it. The restrict processing, I think Soykan also mentioned that among the principles that limitation and not processing unnecessary data is a very important principle of both GDPR and Data Protection Act in UK. So you can always restrict processing that is excessive
to the purpose.
To the purpose, or service you're getting. You can always access to. In order to understand it, maybe you should have first access. Then you can realize that it is that some of the data is actually excessive to the service you are being provided, or the purpose itself, and then you can always ask to restrict the processing. And data portability, this is more about like the mapping and who the data is being shared with. And right to object, obviously, it's also an self-explanatory issue. And also, you have always you have rights on automated decision making. This is, and maybe it's a bit harder to understand on our everyday life, but we usually have we are being subject to automated decision making when we are looking at our credit score, and sometimes even onboarding. We just take some photos and take some photos of or IDs and trying to be on board to financial institutions. I think from practical point of view, this has been a kind of trend, and I think it is working very well. Usually financial institutions decide to make only positive decisions on automated decision making, and if something negative or adverse comes up, and then there is always a manual process. I think GDPR, this is also complying with the GDPR because it could it could be even worse if you are subject to an automated decision making. Let's say that they couldn't really understand the some of the data that you sent the scans of, and then you just rejected by a bank, or you're just rejected from a loan application, which would be could be disastrous for some instances. So what is being trend, and what I also support, is to have only positive decisions on automated decision making, and all adverse decision making being subject to a kind of manual further process. And yeah, I think these are the main principles, not main principles, but main subject rights. Yeah, I think, yeah, we can go to data protection officer. Is there anyone who is working as a designated DPO in their work? Maybe we can just see a number or someone raising hand. I will just wait for another 5, 6
seconds, yeah,
for them to decide if they want to hands up. No, I won't ask, further questions. I will just need a number. No, okay, yeah, it's good. And I think one of the myths about being a data protection officer is that people are kind of scared of being personally liable or getting into trouble. And I can easily say that it is very unlikely, because as I will just explain further, the data protection officer is actually responsible from like organizing data protection issues within firm, but it's not a role like money laundering reporting officer. I think it's a bit lighter role when it comes to the regulatory, personal risk and liability. What are the main tasks of a data protection officer in an organization? It's being a point of contact for the supervisory authority, which is ICO in UK, and different authorities within the European Union, and advise all employees on GDPR obligations. Yes, this internal trainings and being up to date about the data protection realities and information is very important for data protection officer as well, to monitor compliance with GDPR. It is, I think, also getting very important, and it is getting more complex day by day, because the GDPR and the data flows are getting even more complex day by day. To oversee staff data protection awareness and training, I think this is also related to advice on GDPR obligations. This could be either a specific case, or just a regular training to keep the company and the employees up to date, and also to review audit GDPR policies and procedures. I think this is one of the starting points if your organization doesn't have one, because the policies and procedures are key. And once you're dealing with the regulator, this is going to be the first thing they will be asking. So if first thing first, for a DPO to have necessary policies, procedures, and necessary escalation points, so everybody should know what are the what are the responsibilities, what are the tasks, and who they should be escalating issues when they are not able to sort by themselves. I think this is very important to have. And this goes back to the original point of audit. I think if your organization is lacking GDPR compliance, I think the first point should be going into an internal audit and then making policies and procedures up to date, and then have a training starting from the DPO, so DPO can pass this training to other employees. And I worked personally with CFE certification on different, auditing and also compliance projects, and they are doing an excellent job. And I think anyone who thinks that their organization is missing some of the issues that we have been going through, they can feel free to both ask questions to our personal emails, but also to reach out CFO Cert for any audit or further compliance projects. So yeah, after DPO's roles and responsibilities, I think who can't be DPO, I think we haven't received anyone being DPO, but if you are willing to do, if you are going to do, just be sure that you're not also holding a role which could conflict, especially with the data flow. And if you are making important decisions about the data flow, like CTO, designated safeguarding person, or like information systems manager, this could very likely to be conflicting with the other DPO roles, and this should be really noted. But other than that, the DPO actually can fulfill other tasks and duties which are not conflicting with the DPO role itself. I think we can pass this slide. Yeah, data breaches and notifications. First, what is a personal data breach? I think we can start to define it. A personal data breach means a breach of security leading to accidental or unlawful destruction, loss, alteration, or unauthorized disclosure or access to personal data. So it's a very wide definition. This could happen by way of destruction, by way of loss, or unauthorized access or disclosure. And these could very well happen both accidentally and deliberate causes. I know that nobody wants, nobody deliberately wants to have a data breach, but some people do, obviously. So we all need to. That is actually another point that a firm-wide awareness should be implemented when it comes to GDPR guidance, because it doesn't up to one person. Or you can have the best DPO in the world, but if you don't have the awareness all among your employees and around your organization, you're still very unlikely to prevent any data breaches, and you will probably be exposed to data breach still. For example, what are the main examples, let's say, that leads to a data breach? This could be either access by an authorized third party, or an action by a controller or processor, and sending personal data to an incorrect recipient, which actually happens a lot, and computing devices containing personal data being lost, stolen, or being left, unattended, alteration of personal data without permission, and loss of availability of personal data, like losing of keys or any other means of access to data if data is only being stored there. So at a glance, we could say that the UK data protection rules introduce a duty of all organizations to report certain personal data breaches to the relevant supervisory authority, which we say it's ICO, and there is a time limit that we need to do it on 72 hours of becoming aware of the breach where feasible. So it's becoming aware is not necessarily be the time that that data breach happened, but this is the first moment that a reasonable person should be aware of, or you literally became aware of. And if the breach is very likely to result in a high risk adversely affecting individuals' rights and freedoms, you must also inform those individuals without undue delay. So anyone being affected should be communicated without undue delay. This is also very important. And when we are talking about the policies and the employee awareness, this gets us to that point actually, because if a person who becomes aware doesn't know their duties and how to escalate it, you're very exposed to breach also the regulation itself, because breaching personal data breach is one thing, but you can still comply with any other duties that you have under GDPR or data protection rules. But if you don't have the awareness among your institution, that you are very likely to breach both. So so you should what you should do to prevent data breaches. So is there any ideas from the crowd that like I think we have one question, but it is in most probably Spanish language. Is it? So
it's Nathaniel. Yeah, it's in
Nathaniel.
Spanish.
Please feel free to ask, and again in English. Yeah, I guess. Yeah. So what measures can you take to prevent data breaches? So what is the most effective way to fight with maybe or prevent data breaches in your opinion? Yeah. Shreya, many thanks. I think Shreya touched very good points. One, records of processing activities. This is also being identified as data mapping, which Soykan initially mentioned. So if you know how data comes into your institution and how it's going and who you're sharing it with, so you're very likely to get to know who are being affected and what could be done to stop it in a very short amount of time, and also data like impact assessment. Also, Shreya, I think she meant that impact assessment policy is very important policy among other policies in terms of GDPR or data protection, because it helps you to identify and define what is the possible possible effects of specific breach or action. Many thanks, Shreya. I think these both were very useful, and thanks for noting those.
Should I move?
Apart from that, I think lastly, apart from keeping record of data breaches is also important, so you can learn from your mistakes, because one time, you're breaching personal data, it's not end of the world, but you have to have a log. So you should be able to feedback and see if what happened and what was the effect, how did you solve it, so it will just help you for further events as well. And also one of the important things, this is also getting back to the assessment, like impact assessment as well, but you should have internal reporting procedure and investigation procedure in place, and this will also facilitate decision making about whether or not you need to notify relevant supervisory authority and affected individuals, or both. I think these are the main points, and we can get to that.
And
I can maybe have a sip of water before we continue. Yeah, supervisory authority, that's the main authority, and a designated DPO would very likely to be, to contact them with supervisory authority most of the time. And for UK, I think we mentioned a couple of times that's ICO, and now ICO's duties are monitoring and enforcing the application of not the GDPR but the Data Protection Act, which could derive from the GDPR, but they are now
more or less the same.
Almost in line, we could say, and promoting public awareness and understanding of the rules and individuals' rights. Ensure the controllers' processes are aware of the obligations, conduct investigations and applications of the data protection rules, and establish, maintain a list of data protection impact assessment requirements. I don't know what you think about SOICAM, but I find ICO's website very clear, and I think anyone who are not even
have knowledge.
Yeah, non-legal or like non-compliance person can even, I think, understand, which makes it easy for smaller financial institutions to go with the compliance. I don't know if you agree, but I think
I checked their website recently, and it's really good. Like they have this like at a glance part of each subject, so it's very easy and like on point information there related to GDPR. So yeah, everyone can check and understand it easily, as you said.
Yeah, I think now we are looking from the financial institutions perspective, and some of the fintech firms, they have to combine their, they don't have a data protection team, and sometimes they have to combine it with legal, with sometimes even risk, compliance, legal, and data protection. One, two people, and this could be overwhelming for this, people to be on top of everything. But I think ICO is doing a great job when it comes to being clear and to the point, as you said. And some of the, I think, European regulators are kind of missing that, but hopefully it will also improve on a short amount of time, we could say. I think we have no questions. Okay. Yeah, we can go to the next slide, I guess.
Okay.
Yes. So, yeah, ICO, I think we mentioned.
We mentioned this,
ICO's statement is to uphold information rights in the public interest, promoting openness by public bodies and data privacy for individuals. This is the main
history again here, the timeline.
We can say, and for further information, you can always check Article 57 of the GDPR for full list of duties of a supervisory body under GDPR, and for like generic from regulation perspective, what a supervisory authority does under GDPR. So you can, for further information, you can always go to Article 57. So this gets us to one point. Data transfers outside EU. Now, as you are well aware, UK, after the Brexit, that was one of the hot topics that, like, okay, what are we gonna do? Are we gonna continue data transfers between EU and UK, because it was that was a kind of cool-off period after the Brexit agreement was reached, and everybody was having hard nights, let's say, having troubles to sleep, especially privacy professionals. But luckily, UK and EU agreed on an adequacy decision. So now I think it's not really, while UK being a third country from EU legislative perspective, I think data transfers are now still relatively easier thanks to the adequacy decision. But the adequacy decision is not the only way that allows data transfers between EU and other countries. And from GDPR's perspective, this could be either an adequacy decision by the Commission, or legally binding and enforceable instrument, binding corporate rules, standard data protection clauses, approved certification mechanism, or contractual clauses. So I think most popular ones are adequacy decisions or standard protection clauses. And because I think binding corporate rules are designed for big, like worldwide big firms like, I don't know, Amazon or like Google or Facebook, to adopt those rules, so they don't have to spend so much time on transferring data between their entities. And I don't want to say it's failing, but it is less likely to be applied due to the procedural problems, and probably companies don't want to bother themselves with so much work. But of course, big companies are still on that. From my personal experience, I think what I've seen most is standard data protection clauses. It's easier to just add it to an addendum, to your data protection addendum, like an addendum of an addendum, or maybe like an exhibit of an addendum, or just go for like the jurisdictions that you have adequacy decision, which will make your life very, very easier. From your personal view, Soykan, what do you want to add something, or like?
No, I think like while you were like mentioning the big companies globally, maybe we can move on to penalties and sanctions.
Yeah, please.
Yep.
I mean, the penalties and sanctions these usually occur to the big companies, because we have to, I think, we have to accept and see that GDPR and like data protection, like any other specific regulations, like competition, it is widely and heavily relying on some other third-party lines, let's say, because you can't really check every computer and see if they have taken necessary measures. So you can't go to a limited company and just say that, like, yeah, everyone freeze, open your computer. So I think investigations and most of the penalties and sanctions, they're more likely to occur on big firms, or
upon a breach, big
yes.
breach, let's say, because as these guys have lots of customers, lots of merchants, their potential to have a breach is more than, like, let's say, small or medium businesses.
Yes, yes. And I think nobody has, most of the regulators, probably including ICU, I don't know the latest status of ICU, but most of the regulators that I know, they're understaffed, and they're not able to just chase every company. So that's why probably all we hear is, Amazon being fined for like almost 1 billion euros. And like, I think Google recently got fined, and the European regulator asked Google to add a section, or like a pop-up to refuse all the cookies. And also H&M, they were kind of, I think, fined around 35 million euros by German regulator, and this, just continues like forever.
Yes. So with these penalties and sanctions, I guess even the big companies are getting in line regarding the GDPR rules and procedures. Yeah. And you can see it's getting even stricter online to let's say just become a member of a company or have an account. You need to click lots of boxes before you open an account. So the main reason behind them, as I said, to avoid these complaints and avoid these penalties, which are really like, as Caner said, it's almost like a 1 billion euros fine to Amazon lately.
Yeah. And also it usually happens with the retailers, because the administrative fines are either capped with 20 million euros or not, and 4% of the total worldwide annual turnover. So when you're a retailer having a huge turnover, you're actually more exposed to a bigger fine that is very likely to be on the newspapers rather than a small like 5-person accountancy firm that doesn't have this turnover, and probably impact will be way bigger when you're a worldwide company having a big turnover dealing with the retail, right?
Yeah.
I think we have another question. Coming from probably YouTube. What method?
I think this is the translation of the Spanish question.
Okay. Oh yeah, that's thanks whoever provided that translation. There are two questions. Okay, it's cool. I like the questions. So what method is used to detect if the data is provided even from Department of Finance? Okay, I don't know which. It's hard to say without knowing which data, but if the data is provided by finance, then it's probably going back to the same topic that it should be coming from somewhere that you should be identifying it with the mapping. So if it's an employee data, you probably have the consent. At least you can be probably do about it, because as in your employment contract, you are very you're very likely to getting any consent from employee to have the relevant information. But I think what it makes sense, and when it gets to one simple topic, that if you have a mapping organization and you know which data is coming from where, and you are able to just track it down until you share it with someone, or like until you just erase it when it comes to the point that you don't really need it anymore. And when you have the policies to follow that, it becomes easier to track any data, whoever it is related to, wherever it comes from. It comes to that point that you should have the mapping and relevant policies and escalation measures or mechanisms within the firm. So if you, for example, if you have recently experienced such one simple occasion, and if you're not able to identify where it comes from and what to do with that information, it is very likely that your data policies needs to be improved or remediated, or your process should be rechecked. So that's why we I think mentioned the importance of the audit gap, and which is I think a great way to understand and avoid situations like you mentioned. I hope that helped. I think it's coming from Nathaniel. Yeah, Nathaniel Santos. Another question: How protect data personal and drop breach when your company use blockchain? Yes, that's a very good point as well. In blockchain system itself is actually very open to that, but I think from my personal experience, when you're using a blockchain-based system which is designed to be open to the world, it is very important to use a third party, someone that you can rely on from the technical perspective. It is also a great gray area, like it is
very new gray. Yeah, you need to implement the same like technologies, like as the technology goes forward, the measures, the security, let's say implementations are also improving as well. So there is, as Caner mentioned, there's lots of third party, let's say businesses that can help you for this data protection that is used through blockchain system.
I think from blockchain system, what was the best point is, for example, when it comes to the crypto, of course, blockchain has very wider, application areas. But for example, for like crypto wallets or like cryptocurrency transactions, the main comfort was not being identified, because if you so you can track a wallet, but you can actually track whose it is. So as long as you are not able to identify that person, it doesn't constitute the personal data itself. And this was the comfort. But now blockchain is getting very more complicated, and there are like learning systems based on blockchain. There are other systems based on blockchain that could really lead up to a data which you can associate and identify a person behind it. In order to not get caught by this, anything that could become identifiable should be maybe divided into different infrastructures, and personal data and identifiable data should be divided from other data, or they should be anonymized, and there should be enough safeguards that a person who is trying to identify that person will not be able to do that unless they have necessary keys or something. I hope that helps, because it could be actually another webinar topic. It's a very wide topic, but in a nutshell, I think it is the important considerations to make. I hope that it helps Nathaniel Santos. Thanks. I think these were great questions, by the way. Many thanks.
Yes, thank you, Nathaniel. Also, let's move forward, Caner, as we already passed 1 hour.
Yes,
so let's move on to how does GDPR impact financial institutions. Caner, would you like to talk about it? We can.
Well, I think from my personal, it is just summarizing things up. The financial institutions, they need to get better at using softwares and technology in order to tackle challenges when it comes to the GDPR. Because as long as you're using the manual systems, you are always
open to breach.
Yes, exposed.
The more automated system, the better and safer it is.
Yes, and from cost perspective, I think it's sometimes easier to use third-party providers or softwares rather than just dealing with manual process or like remediating the manual process, especially for small firms, small institutions like fintech firms. I would really start looking at the softwares to the extent possible and minimize the manual processes and risks. I think that's the best. Not even you don't even need to download a document to your personal computer right now. Everything could be done on either G Drive or Microsoft 365, and this gives very better comfort to anyone, any supplier, any regulator than any manual process. Even if you are all GDPR experts, I guess. And
financial.
So, you want to maybe just like
I will go over these quickly. So, financial institution data governance, as Caner earlier mentioned, that you need to build in your financial institution, you need to have your own data governance. So, like policies, procedures, depending on how big your firm is, you need to build these governance. This will help you follow the procedures and be in line with what you need to do. At a high level, I would like to mention this, what financial organizations and institutions needs to do. So the institution needs to build an inventory of personal information held by the organization, including the nature of the information, the locations where it is stored, and the purpose of the collection. So this is basically saying where the data is stored, it should be recorded, and what information is, as we mentioned in the data map, it's data audit and data map. It's a similar process here too. Obtain clear consent prior to collecting and processing the personal information. We mentioned this earlier as well. Establishing processes to enforce an individual's right to data erasure and right to be forgotten. As you know, this is a very common topic and discussion, that the right to be forgotten and the right to erase your data, which is held by third parties. You need to establish these processes. So let's say a customer comes to you and he says or she says, I want you, like, we terminated the contract with you and I want to delete, I want to have it deleted from your system, that my personal data is collected. So you need to have this process. If you don't have this process, you can't provide this deletion, and then it will also cause problems before the regulators.
Yeah, and I think from historical perspective, if I'm not wrong, I'm not 100% sure, but that was probably the first big fine that Google had that was related to right of erasure in terms of, I think, their Spanish, branch or Spanish subsidiary. So it is actually one of the pioneer rights and pioneer breaches when it comes to GDPR history. Yeah, just as a fun fact.
Yeah. Another thing that the financial organization should do, implementing data management and the identification systems to remove a data subject's identifiable data from the personal information prior to sharing whenever possible. Also, manage the flow of information to vendors and through third-party information systems. Develop breach notification process. So you need to have all these governance. So once there is a breach or there's an information that you are going to store, you need to store and process according to your internal data governance. Moving to the next slide.
Yeah, I think I can just go briefly. I went through all of it already. These are the very high level, very fundamental key points to consider for financial institutions. As you said, people and training. Even if you have the best systems, if you don't have people who can see this is a breach and your countdown has started, you're very likely to be exposed to breach. And your data protection officer, it doesn't have to be someone, it doesn't have to be your, it shouldn't actually have to be your, the CTO, it doesn't have to be your compliance manager, it doesn't have to be your legal manager. And I know, including CFE cert, great firms, they're providing outsourced DPO service. So in order to speed up, in order to accelerate your compliance, you can always ask for a third-party help and get a designated DPO.
Also for transferring the responsibility.
Exactly.
Yeah.
You can always have someone to blame at the end of it, right?
Yes.
And yeah, third parties, which third parties you are working with? If you're working with some companies from Colombia, it's not the same with some companies you're working with, for example, like Germany.
Within the EU.
Geographical scope and your data flow and data journey is also very important. Data limitation, I think we went through that a lot. You don't need, you shouldn't process any data that you don't really need necessarily for the service you're providing. And budgets, I think this is a consideration that changes from every financial institution. For smaller ones, I think we mentioned that always using help and onboarding necessary softwares, ultimately actually making you save even more than you think. And breaches, you have to have necessary policies.
Implementations.
Yeah, and subject access requests. You need to have people in training and policies to be able to respond them on a timely manner.
Yeah,
I think these are the main important points. And
yes, moving to the next slide.
yes, yeah, beyond compliance, using GDPR for competitor advantage. I think Sokan, you will probably agree with me. For example, when you're dealing with a supplier, sometimes even when I was working as a company secretary for Financials Limited, I remember that boards were asking if they have ISO certification, where they are located, where their servers are located. So it comes to a point that your GDPR compliance can be actually your competitor advantage over some other firms, because when you're able to give necessary comfort to your potential partner, you're actually more likely to be selected over competitor, right? So
yes, exactly. So please don't feel, let's say, you should implement as much as GDPR procedures and measures and implementation, and as Jana said, technologies in order to move one step ahead from your competitors.
I think people sometimes owners or like some firms likely to see GDPR as a money spender, but it could be a money earner at some point.
If you can promote it in a good way. Yes, exactly. And also at the end, if you face a breach and if you get fined by the regulator, it's like 2 to 4% of your annual revenue, not profits, revenue. Yeah. So it's not a joke, you know. You need to take the measures.
Yeah, I think it's very one of the hard points of being a privacy professional or a regulatory lawyer or professional, because nobody applauds you when Google gets fined and you don't, but if you get fined, you're in trouble. So
yes, exactly.
It is one of the downsides of working on the regulatory area, because nobody gets to appreciate you on a passive success you've been providing for a while.
Yeah, and our last slide is your data strategy. This is the similar things that we said. Please treat these data as it's a high value asset, because it can cause you problem, and it can also gives you more value in return if you keep these data safe, and if you don't face any breaches. It will bring value to your company, value to your business.
Yeah, I think before we finish, we have one last question from Nathaniel. In case of blockchain, the problem is being revocation of the consent. I think she's asking for how to create a consent. That's actually a very good point. And blockchain, it comes to a point that which jurisdiction or like what kind of a data subject you are dealing with, but I know that most of the jurisdictions, they have now tendency to accept smart contracts as legally enforceable contracts.
Binding. Yeah.
So if you can actually implement necessary openness and clearness on a consent on a smart contract, that it is very likely to be accepted as a consent by relevant regulator. Because in gray areas, I think sometimes it's not easy to have everything, but if you can demonstrate that you are just giving enough importance and you're doing whatever you can in gray areas for transition periods or initial period, I think that's still helpful. And from blockchain consent perspective, I think now smart contracts are the only way that anyone could think of, and hopefully then we will get a clearer guidance and developments on that area.
Yeah, it's not fully regulated yet, the blockchain and crypto businesses. So as Caner said, it's not clear, but it will be in a couple of years, hopefully.
Yeah.
So this was the end of our webinar. If you have any questions, you have our personal email addresses in the beginning of the slide. This slideshow will be sent to you by CFE Cert, so you can see our emails. Also, anything related to CFE certification, you can email these email addresses on the screen to get any information or any services from CFE certification. We will wait a couple of seconds for any questions that you have. If not, or if you have like questions in the future, as we said, you can always email us.
Yes, exactly. I think from my personal experience, I've pretty much enjoyed working with a CFO certification board when they're providing DPO services as outsourced, and also remediation or like policy making or process making services when they're doing. And I would really advise anyone who's having troubles to get this done to reach out CFO Cert for any help. And if anything comes up for the points that we have discussed today, I think Soykan also mentioned our personal emails and LinkedIn. You can reach out to us from
you can
personal emails.
Yes.
For any further questions that we would be more than happy to share out some information for further for further sharing of knowledge.
I think Georgina says thank you. Yes, Georgina, of course you can reach out to us. We are happy to discuss. We are happy to help, either like for GDPR reason or like legal perspectives, as well, as we are both lawyers. We are happy to help you in any matters.
Exactly. It's great to hear you enjoyed the content, and we hope to see you on further subjects and webinars or somewhere around the world.
Okay. Thank you all. Take care.
Yeah. Thanks everyone. Yeah. Thanks, Nathaniel. Yeah.
Bye-bye.